Division 1 is now in session.
Thank you. Please be seated. Good afternoon. Thank you for your courtesy. This is the time set for oral argument in our special action cause number 1CA SA140037, Andy Biggs and others as petitioners versus the Honorable Catherine Cooper and others as real parties in interest. As you know, each side has 20 minutes aside. If counsel for petitioners wishes to save some time for rebuttal, let us know and we'll try to honor that. When you come to speak, if you would state your name for our unofficial recording, we would appreciate it. And let's see, I think I can tell you the following as well. We have not made any decision on whether to accept jurisdiction. If we decide to accept jurisdiction, which we obviously haven't decided yet, we haven't decided what we might do. One option being to address the issues the trial court addressed. Another option might include addressing more issues, perhaps with supplemental briefing. But we have some questions on all of those areas for you. Who's going to argue?
The petitioners, Your Honor, Christina Sandifer, I'm here with Kurt Altman.
You may proceed.
Good afternoon. For the record, Christina Sandifer on behalf of the petitioners. And I'd like to reserve 5 minutes for a rebuttal, please.
Very well.
All right. May it please the court. In this case, a coalition of 36 legislators, 2 constituents, and a taxpayer are challenging the illegal Medicaid tax for a violation of the constitutional supermajority requirement. Now, the trial court said that none of these
plaintiffs have standing, but in fact, they all do.
Well, counsel, before we get to that issue, I understand that there's an appeal in this case.
Yes, Your Honor, that's correct.
Then why can't you vindicate your rights through that appeal rather than this special action?
Sure, Your Honor. The petitioners do not have an equally plain, speedy, or adequate remedy by appeal. The reason that petitioners filed the notice of appeal is to preserve their right to appeal. Oftentimes, the Supreme Court, or the Court of Appeals, rather, will not take a special action, and so they wanted to be sure to preserve their right to appeal.
Well, I'm not criticizing you for doing that, but my question remains: why can't you just raise the same arguments I think you're going to raise here on your appeal?
Absolutely, Your Honor. First of all, on the standing issue itself, the decision below is at odds with well-established Arizona Supreme Court precedent, including a case that just came out days after petitioners filed their action in the trial court.
But why can't you raise that on appeal?
Because, Your Honor, the standing issues here are very important to the integrity of the legislative process and to the budget process as well. If legislators are not able to assert standing and in order to preserve the integrity of the legislative process and in order to preserve the right to vote, then that is going to be very detrimental to the budget process itself.
But in a sense, excuse me for interrupting, in a sense, isn't it better to have the sort of standard appeal process, which is perhaps takes a little bit longer, but allows a full record, allows more time, more briefing, more consideration. The issues of this importance, aren't they better suited for an appeal really than for a special action?
Your Honor, we don't believe so. There really does not need to be a development of the record anymore at this point. The issue is pretty straightforward on standing. And again, we think that there are many controlling cases both in Arizona and in the federal courts. And so there really needs to be no additional development. In addition, this is a dispute at the highest level of government. These are issues that are likely to recur. Again, these affect the budget process, and they're issues of state importance, and they're pure questions of law. Those are all areas where this court and the Supreme Court have taken cases on special action before. In addition to the standing issues.
Are you suggesting that there's an urgency, and if so, in what way?
There is an urgency, Your Honor, and not only because, again, the standing issue here needs to be resolved so that legislators have clear guidance on whether or not they can preserve their rights in the future and assert real injuries, but also we have the underlying merits at issue here. When petitioners filed this case last year, the tax that is at issue here was not in effect. It went into effect in January, and so now every single day that we go by without even a decision on standing, this appeal could take over another year, and then we have a potentially unconstitutional tax that's being assessed at the.
So did you seek an injunction to keep the tax from going into effect so that you could pursue your claims?
At the time, Your Honor, we did not seek an injunction in the trial court simply because the tax had not been in effect yet. This is now out of the trial court's jurisdiction, and that's why we can no longer seek an injunction in the trial court. But also the importance here is that the legislature is in session now. And so if this tax is found to be unconstitutional, of course, the entire new Medicaid program is without a funding source. The legislature can go back and find a constitutional funding source and replace what exists right now and keep the program intact if it needs to do that. And so that's why we think that this case is very important for resolution on special action now, rather than waiting years in the future. And again, Your Honor, even if we were to go and seek an injunction, I think that we'd be right back before you because I'm sure that the defendants below would probably challenge that. Eventually, this issue is going to end up here anyway. It's an issue of grave statewide importance, and that's why we think that it's important to resolve it now rather than later.
On to the standing issue of the legislators. The legislators have standing here to challenge a nullification of their individual votes. Now, defendants below are probably going to come up here and they're going to tell you, look, this is just a political dispute within the legislature itself. That's what they're going to tell you. That's what they've been saying below. But in fact, the petitioners here are not challenging an act that happened within the legislature. They were injured when the governor signed the illegal tax into law, despite the fact that it failed to garner a supermajority.
Does it make any difference that the President of the Senate and the Speaker of the House signed off on it somehow?
Sure, Your Honor. We do not believe that it does for the following reasons. First of all, the Speaker of the House and the President of the Senate were sending a budget to the governor. It had many, many, many moving parts. Now, both the Speaker and the President are on record. They voted against this particular provision, first of all. They're on record saying that it's unconstitutional, as defendants below have helpfully illustrated. In fact, they tried many times to attach Prop 108 language to this bill. We have pages and pages of testimony where they are on record explaining the importance of the constitutional issue here.
When you used the word nullification a moment ago, were you making a distinction between what you believe happened here versus, let's say, simply some legislators lost a vote?
Absolutely, Your Honor, because here the legislators did not lose the vote. And in fact, we hear defendants below say over and over again, look, the legislators here just lost a vote. But the reason that we're here today is because the legislators, in fact, won. They won the vote. The Constitution requires that any tax or revenue-raising measure has to be passed by a supermajority. And in other words, it empowers a minority to block a tax. Here, we had the petitioners here had a minority. They should have blocked the tax. They won that vote. They defeated the tax, and yet it was still signed into law. So they did not, in fact, lose the vote.
Well, I'd like to touch on the question a little bit later as to whether a supermajority was required. But let's assume for a moment that the legislators do have standing to bring count one.
Sure.
Right? Because that is directly, in my eyes, directly implicates their role as legislators, their ability to carry out their function. Does that same rationale really apply to count two?
No, Your Honor, it does not. In fact, the only petitioners here that bring count two is our taxpayer, plaintiff, or private attorney general. The reason it doesn't apply to count two is, of course, that is a separation of powers injury. That is something that the courts here in Arizona and federal courts have called an institutional injury. That is the type of injury that would be properly brought by the legislature as a whole. And in fact, that illustrates very nicely the difference between the institutional injury and the individual injury here, the nullification of a vote. We have many cases. In fact, defendants will probably try to distinguish all of the cases that petitioners have cited for their proposition, but on the issues that are relevant here, all of those cases, in fact, support standing for the nullification of an individual vote. We can look all the way back to 1939, the Coleman case. The court said there that legislators can sue to protect their interest in maintaining the effectiveness of their votes.
Even I wasn't alive then.
Well, so this is very, very long-standing precedent, Your Honor. Reigns in 1997. This is another federal court case. The legislators whose votes would have been sufficient to defeat a specific measure they have standing to sue if the action nonetheless goes into effect on the grounds that their votes have been completely nullified. And then, of course, we know that defendants below are going to say, well, those are federal cases, right? Federal cases are not binding on Arizona courts, which is true, Your Honor. Of course, the federal courts are bound by their constitutional case or controversy requirement, which the courts here are not. And so, as we know, federal courts are very picky about standing. The fact that federal courts have time and again accepted standing on this issue should be instructive.
But standing is not a jurisdictional impediment here, is it, in state court?
It's not. There's no, that's right, Your Honor. There's no constitutional requirement there. It's merely prudential. Nevertheless, the courts here have in fact accepted this line of cases. The Supreme Court in 2003 said in the Bennett case, legislators can sue if the votes against a bill are overridden and virtually held for naught, although the votes would have been sufficient to defeat the measure, but were nullified by illegal interference in the legislative process. This continues to go on. We've got, in 2006, the 47th legislature case. That case, although it was, again, some of these cases are about institutional injuries on the facts, but when they distinguish the individual injuries, they're very clear. Legislators who voted against a measure had standing because their combined votes were sufficient to defeat the measure, and in fact, they'd been overridden. And then again, the Dobson case, which was a special action case that came out just days after petitioners filed this action. Individuals can sue if an act directly alters how the votes of the individuals will determine a collective body's action and renders a member's opposition ineffective. That is exactly what is going on here.
Well, I know we have, we're talking about standing now, but we have a little bit of a chicken and the egg problem, because if the standing is based upon the notion that the vote was nullified because a supermajority was required, I want to give you a chance to address something that respondents addressed in the response, but was not addressed either in the petition or the reply, and that's Section C2 of Article 22, which seems to describe as an exception to the supermajority requirement an act very much like what you're challenging.
Sure, Your Honor. So first of all, for purposes of standing, of course, it's a motion to dismiss. We have to accept the petitioner's allegations as true. And so for purposes of standing, we have to assume that Prop 108, in fact, does apply.
Well, we have to assume the truth of the factual allegations. We don't have to assume any legal proposition that you advance.
Sure, Your Honor. If in fact this court were to look into the merits of that actual part, that exception applies to. That exception does not. It applies to measures that were authorized by statute but have no limit, and that are exercised by an administrator. That's roughly what it says. Now, the authorized by statute.
Somewhat similar to what your count 2 alleges.
But the authorized by statute part is the problem, among other problems. And the problem there is that exception would swallow the rule. If we were to say that, look, voters cared so much about curbing government power, they cared so much about making sure that a supermajority of the legislature, who are in fact accountable to the people in some sense because of elections, that legislature has to pass a tax by a supermajority. But if the legislature decides to go ahead and delegate its legislative authority to some administrator, then no supermajority required. What that provision means, Your Honor, is that as long as the legislature authorizes by a supermajority the tax, then the administrator does not have to go back to the legislature, assuming no delegation problem, every single time he wants to tweak the amount.
It doesn't really say that, though. I mean, it sounds like another rational construction might very well be that the statute you have here is an exception to the supermajority requirement, but there may be a delegation problem down the road when you analyze what the statute does. I mean, if, for example, the statute allowed the director of the MVD to set driver's license application fees and raise them by $3, I doubt that it would be quite as compelling a case for an unlawful delegation as if it allowed the governor to simply levy income taxes with no formula. That would be a problem.
Absolutely. I'm sorry.
Go ahead.
No, absolutely, Your Honor. And on the delegation problem, absolutely, that is virtually what this provision actually does for the director of the Medicaid program. However, when the statute, in that exception, when it says authorized by statute, we need to have some sort of guidance as to how the legislature authorizes the collection of a fee or an assessment, and in fact, or a tax. And in fact, the way that we know that is we look to that constitutional provision itself. The legislature authorizes the collection of a revenue-raising measure, in fact, by a two-thirds supermajority vote. Again, otherwise, the exception would swallow the rule, and that just that really doesn't make sense within the context of the constitutional provision itself.
Speaking of which, you don't have much time left, and we haven't given you an opportunity to address the trial court's reasoning. Do you want to do that?
Subsection D?
Yeah.
Yes, Your Honor. Thank you very much. The trial court says that somehow, and the defendants below as well, said that, well, okay, if maybe we can't deny the injury itself, but, the majority of legislators came in and voted not to apply Prop 108. Well, again, the majority of legislators can't deprive the minority of their right to sue, and the majority of legislators can't come in and say that a constitutional provision doesn't apply. That is for the courts. But it's also a red herring, because we aren't challenging the Prop 108 clause or whatever we want to call it. The petitioners here are not challenging that portion. They're challenging the fact that their votes were nullified when the tax law was signed into law. And so
You're not challenging the absence of language.
We're not challenging the absence of language. If anything, Your Honor, that makes this even more deficient, because the Constitution is clear. It says shall include. That when Prop 108 applies, which again is a judicial question and not a question for the legislature, ultimately, even if the legislature has to make that determination, as it always does with any law, initially, that provision must be included when Prop 108 applies. If the legislature did not include it, in fact, that just makes this bill more deficient. But what our petitioners here are challenging is not something that the legislature itself did by majority, but the nullification of their vote. And the court below, the court decision below, is basically saying that a majority can deprive a minority of its right to sue, to enforce its rights. That can't be right. If there are no further questions, I see that I only have a few minutes left, and I'd like to reserve those for rebuttal, if that's all right.
You certainly can.
Thank you.
We probably have lots of questions, but we're limited on the time as well.
May it please the court, Doug Northup representing the respondents. On the jurisdiction question, I'd like to start with Judge Howe's question that he was asking about whether jurisdiction should be granted. The reason for urgency here is stated on the petition at page 7. The longer in the delay in resolution, the greater the impact on Arizona taxpayers. The purported taxpayer here, the hospitals, aren't complaining, and the urgency doesn't exist for the petitioners who are claiming vote nullification, dilution, or whatever it is. That occurred a year ago. If anything, there's not urgency, and this is a case that should be fully developed to make sure we get it right.
Well, how much more fully developed can it be? It's over in the trial court. We have the record that exists, and what more are we going to do to develop it?
Well, I mean, that's a good question, although when these things come up at the briefing, I think our response brief was doing something like a week. Our response looks very much like we filed in the trial court below. You all are under much greater time constraints, and I can't stand here and say, oh, well, I would have made the following 3 arguments, but it is a much more compressed time frame, and especially...
But we could give you the opportunity for supplemental briefing, as Judge Gemmell has suggested is a possibility, right?
Well, I'm not sure if he was talking about that or there's the petitioner's suggestion on supplemental briefing on the merits, but there's another issue here where there is a right to appeal pending. If petitioners can come in when there's not an urgency that applies to them, to the harm that they're claiming, and get relief on a special action instead of appeal, that's essentially creating an incentive for other petitioners to say, let's file a petition for special action because we can jump in line in front of everyone else.
But there aren't very many cases that involve the governor and one of the directors on one side and a number of the legislators on the other. Shouldn't we, as a courtesy, as an accommodation to the other branches of government, accelerate this case?
You know, Your Honor, you certainly have the discretion to do that. We don't think it's an appropriate situation, especially if there really was urgency that related to the petitioners, then those would play into it. But the urgency that is being urged here doesn't have anything to do with the petitioner's harm, and we would respectfully suggest this is not a case to accelerate and accept.
Let me throw out a hypothetical, an extreme hypothetical then that will go both to jurisdiction and standing. These legislators are claiming that their votes have been nullified. the legal merits of that are subject to a separate debate. But if you had a situation where one legislator in the dead of night managed to fraudulently get a bill that hadn't even been voted on to the governor's desk, and the governor signed it, purporting to be a law, I assume that would present something in the nature of a constitutional crisis, and you probably wouldn't object to special action jurisdiction at that point. Am I correct?
You know, it's hard to answer that because there's an awful lot of unknowns in there, and there's a lot of reasons I think why it would never.
Well, I made it extreme for a reason, but an obvious failure of the legislative process, such that anyone would agree it offended the Constitution because there had been no vote.
I think certainly that's an extreme example, and I suppose it could depend on what the subject of the legislation was, whether it was something that affected a lot of people or whatever. I mean, in those circumstances, that's why the court has discretion to accept jurisdiction.
Okay.
But in a situation like this where the urgency doesn't relate to the petitioners, we don't think it would set good precedent to accept and grant relief. But obviously the court can do that.
What about standing in that situation? Would a legislature who is denied the opportunity to vote on the bill have standing to challenge the process?
You know, I don't think that they would. I mean, there's a lot of, I think, procedural reasons within the legislature why that couldn't happen. But, you know, I guess it's really hard to answer a hypothetical in the absence of a lot of those facts. I mean, I'd like to talk about this particular situation because if we can always find extremes that, you know, where do you draw the line? But I think
okay, well, let's talk about this particular situation again then, and let's assume for the sake of argument that petitioners are right on the merits that subsection C2 doesn't apply and that a supermajority was required. Does the inability of a legislator to see the constitutional force of his or her vote realized in law raise a distinct individual injury?
No, not under the precedent, Your Honor. And one of the things that's really important, and you talked about this in the opening argument, is the Constitution contains subsection D, which has to mean something. And it says, each act to which this section applies shall include a separate provision designated as subject to the proposition. If that exists, then the bill cannot pass without a 2/3 majority. In this case, however, the petitioners made 3 different attempts. They could have not even brought this to the floor for a vote. The president and the speaker had that power, yet they did. The vote was made. There were 3 different floor amendments proposed to add the Prop 108 language, and they were voted down. And there's nothing in subsection D that suggests there's a supermajority requirement.
Well, but then that would sort of render the entire constitutional amendment toothless, wouldn't it? If a simple majority could decide that no supermajority is required, when would a supermajority ever be required?
Well, but this is the key, though, Your Honor. The people that are subject to the purported tax can always challenge it. The rule that petitioners are asking for is anytime there's a supermajority requirement, for example, in the Voter Protection Act, any legislator in the minority can say, wait a minute, that was subject to the Voter Protection Act. I have standing to sue myself, and the court is all of a sudden refereeing disputes. This isn't one branch of the government interfering with another branch of a government. This is things that happen within the legislature. And the answer in these circumstances, we believe under the case law, because there is a remedy, it's not a situation like Dobson where it's going to go, no one else can challenge it, is to say the legislative process ran its course. This is the bill. It shows the ayes and nays. It's signed by the speaker. It's signed by the president. It was transmitted to the governor. She signed it. It was filed. Their votes were counted.
Well, counsel, what incentive do your purported plaintiffs have to challenge the tax?
Well, are you talking about the hospitals?
Yes.
Well, if it's a tax, they have the same incentive that everybody does. I mean, people hate taxes. If I look at something and I say this is an unlawful tax and it wasn't passed properly, I'm going to challenge it. But those are the people that should challenge it. Opening the door to legislators bringing challenges whenever they simply are outvoted is, we think, a very bad precedent and far extends Bennett or Dobson or any of the court cases. And again, Prop 108 was designed to protect the taxpayers from the legislature. It was never suggested, and hasn't been argued, it was to protect legislators from themselves.
Why, if I may, why do you, I gather that you reject the other side's nullification argument, but doesn't that provide a distinction, or why doesn't it provide a distinction in your view between just what we might call a sore loser legislator and one whose vote has actually been nullified?
Well, I mean, in Arizona precedent, the times where specifically there's been a recognition, for example, is in the Clean Elections Campaign versus Brain, where it says it affects your ability to run individually as a legislator, individual injury. But here, if there's a harm, it's really much more like the 47th legislature case, where it would be harm to the legislature as a whole, because there's the assumption, like Judge Swan said, we think here if the record were developed below, and it's very clear that the exception in subsection C2 does apply, but it's an assumption here that, well, this is, because I'm saying it's unconstitutional and require 2/3 vote, then we should be able to bring lawsuits. Anytime that situation arises, and Your Honor, every legislative session, there are numerous bills that contain assessments. If the law is that any minority legislator who voted against that bill has standing to challenge it, every single one of those are going to be disputes that are going to be brought to the court, and they're going to ask you to decide how this internal dispute should be refereed in the legislature. And I think that's a really significant point, because as in Dobson, it was the legislative branch interfering with the judiciary. In the 47th legislature cases, it's an allegation that the executive branch is interfering in the business of the legislature. This is a situation where if anybody were a proper defendant, it would be the other members of the legislature, because they're all in the majority. And again, subsection D has to mean something. And if it means that it goes up for a floor amendment like happened here and you get outvoted, your vote is counted. It's not nullified. But the consequence of that doesn't mean that if this really is a tax, you get off scot-free. It doesn't mean in a Voter Protection Act case that nobody can challenge it. The people who are harmed by it can always challenge it, and we've seen that happen under Prop 108 and the Voter Protection Act.
Could a legislator challenge a purported violation of the Voter Protection Act?
We think not. I mean, if it were a situation like this, and the Voter Protection Act has the same language that it has to be designated as subject to the bill.
And why is a legislator inferior to any other voter or taxpayer?
Because the question of standing ties to injury, individualized and particularized injury. And that legislator is not injured in his capacity or her capacity as a legislator because they voted. They lost the process. The Constitution provides that both houses of the legislature make their own rules. And there are a number of procedural rules could be changed. So it says if it's a Prop 108 case, 1/3 plus 1, and you get to put the subsection D language. As I mentioned, the Speaker and the President could have said, I'm not bringing this to the floor. We wouldn't be here right now. They have that ability, but what they're asking you to do is come in and referee these internal disputes among the legislature. And when we really look at what Prop 108 was designed to protect, the taxpayers from the legislature, those are the folks that will come forward. If this really is a tax.
How can it protect the taxpayers if a majority of the legislature can always defeat it? And if taxpayers come forward and have no standing?
Well, it's not defeating it, Your Honor. It's simply saying if you designate the bill as subject to, then it requires 2/3 or it just doesn't pass. If the majority says, no, this isn't a Prop 108 bill, it's not a Voter Protection Act bill, okay, it passes, it gets signed, it gets filed. But if somebody who has that individualized and particularized injury comes forward, then they've got standing.
A taxpayer? You said it was designed to protect taxpayers.
Well, yeah, and in this particular, not any taxpayer, because one thing, Your Honor, that's important, the hospital assessment applies only to the hospitals, and by statute, it cannot be passed along to anyone. And there's a recent Court of Appeals case, and I just went blank on the name, it's the car rental case, where this court held in the circumstance where somebody who actually rented the car and the fees were passed through said they had standing, and the Court of Appeals said no. This is assessed on the car rental companies, and only they can have standing to challenge this particular assessment, even though in that case the fee was passed through to the renter. Here, it cannot be passed through at all. And so there could come a day when a hospital comes forward and says, you know what? We think this is a tax, and we're going to file a lawsuit. And if that happens, you have someone with particularized injury, and then it would be appropriate for the courts to get involved, but not at this point where it's legislators unhappy with what happened in their own chambers.
So if a hospital was suing, then you would not be taking the position that the legislature is itself the sole determining body of whether Prop 108 applies?
Not at all. I mean, in that circumstance, they would have standing, and we would be having arguments about C2 and its, fee or assessment authorized by statute and set by an agency head, but we wouldn't be talking about standing as to them.
Let me take us in a little bit different direction for a moment, if I can, to talk about sort of a procedural matter. Let's assume that we were to say that there is standing for some, at least, of the petitioners, and that we also were to say that subsection D doesn't mean what the trial judge said it means. How would it be litigated, in your view, to determine whether this was a tax or an assessment, and to determine, as Article 9, Section 22A says, an act that provides a net increase in state revenues? How would that be determined?
Well, I think, Your Honor, if you're talking about, we're off of standing and talking about the merits, that's something that, with all respect, is not appropriate for an appellate court without any record at all to decide, because in this circumstance, whether or not what the meaning of this is, also how the fee is developed, how it's calculated, how it's imposed, would be critically important to whether or not the exception in C2 applies, or whether it is even a net increase in revenue. So
you're saying that discovery and development of facts would be necessary.
Absolutely.
You don't think you'd have a motion to dismiss based on C2?
Well,
I mean, it may not be your preferred course, but could you not file one in good faith?
I mean, we could. My personal view is I don't file a lot of motions to dismiss because they're not often well received, but potentially. But I really think before there could be a determination by a court that this is a tax, it was subject to the proposition and is not subject to the exception, there would have to be development of a record. And that's obviously a really important issue of potentially.
I guess I'm not sure why that is, though. If the issue is the constitutionality of a legislative act, and we have the legislative act and we have the constitutional text, this isn't an as-applied challenge. What more record do we need than the words the legislature wrote?
Well, like I say, I think the question is, were you talking about, I mean, obviously you can determine, is this a fee or assessment authorized by statute, not prescribed? I mean, those parts of it. But they're challenging how this fee, how is it developed? How is it being applied? Those types of things. So, I mean, I'm not saying.
Well, who's talking about that?
Who does it go to?
Who's talking about that?
Well, I mean,
Commissioners seem to be saying this is a tax, and it was required to be passed by a supermajority. That seems to be the extent of it.
Yeah, but Your Honor, it's also important to keep in mind, they chose to file this not as a special action in the trial court or this court or the Supreme Court or anywhere else. They filed it in the trial court. And they didn't file a cross motion to dismiss or anything of the kind in response to standing. And I don't think it's appropriate. I can't stand here right now and say, no, there's no factual issue, there's no record. I think there probably is. Is there a motion to dismiss to be filed? There potentially is, but I don't think it's appropriate to come in, especially when there's appeal pending. You've chosen your course of action and say, Court of Appeals, take this away from the trial court and decide it not only on whether they're standing, which has been discussed so far, but entirely on the merits.
They're not asking us to take it away from the trial court. It's done in the trial court, isn't it? They've got a final judgment and an appeal.
Well, because the complaint was dismissed for lack of standing.
And so there's nothing to take away from the trial court. There's no pending case in the trial court.
If the motion to dismiss were set aside, where were reversed, for example. I mean, I think the merits were never heard there. And like you say, there are aspects of this, a lot of aspects of this that are questions of law.
There was no discussion of the C2, this does not apply, and C2?
None. The merits were not raised at all.
Has that issue been raised in front of us, do you think?
Here?
Yes.
Not at all. I mean, the issue in the case is...
The only papers that mention it, I think, are yours. And it's only briefly mentioned.
Well, it was simply just because the petitioner saying, this is a tax, this is a tax, this is a tax. You know, we just want the court to be aware, to the extent anyone isn't already, just because somebody calls it a tax doesn't mean it's a tax. There are assessments all the time, and, they're generally not challenged, but if they are, they can go through the process. But just because somebody says it's a duck doesn't necessarily mean it's a duck. So I understand your point, Judge Swan, but I don't think, especially the precedent of saying we filed a complaint in the court, it got dismissed, we never raised any argument on the merits, we didn't file a motion to dismiss, a motion for judgment on the pleadings, anything like that. But we want to jump ahead everybody else and say, decide not only the issue that was set forth below, but the issue here. And I don't think that is appropriate to ask the court to do.
Do you think that's appropriate if we decline and your parties are proceeding with an ordinary direct appeal? Do you think that's appropriate to address the C2 merits issue?
I don't think it's any more appropriate in that circumstance than it is here, because it wasn't raised below. I mean, we all pick our poison. If this was so urgent, they could have sought a preliminary injunction or various different remedies. But once you choose your procedural remedy, it's not fair or appropriate to the other litigants or the appellate courts to say, we want to change course because we don't like the ruling that came out of the trial.
Well, the petitioners really have very little incentive to raise C2. That's your
It doesn't
job.
seem to help them.
Well, of course not. But they're just saying it's a tax, and there's a lot of things that go into. I don't think on the merits it is a tax. I think the C2 directly applies, and we could argue
whatever meaning you assign the word tax. Isn't the issue whether under C2 a supermajority is required to pass it, whatever it is? You can call it a tax, call it an assessment, but there is a category of revenue-raising measures to which the supermajority requirement does not apply.
Not in this case, Your Honor. If there were someone who were harmed by this net increase in revenue, absolutely. But when you've got parties, I mean, there are cases that come before the courts, the Bennett case, numerous cases where the courts have said, you know what, you don't have standing. It's a prudential doctrine, but it's an important doctrine. And you know what, like the Raines case, Supreme Court said, you don't have standing, folks. A year later, finally, a plaintiff came forward that was injured, and the Court of Appeals in the Clinton versus City of New York case considered it. But the question is, who's the one who's bringing the lawsuit? If a hospital stepped up tomorrow and said, we're filing a lawsuit, we think this violates Prop 108, then it would be a whole different inquiry. But we have to look, because standing is based on who caused the harm, and in this circumstance,
Excuse me for interrupting, we're out of time, but could we add 3 more minutes to each side, please?
Okay. Do you want me to continue? And
Go
okay.
ahead.
So I really do think, and in this circumstance, the governor signed a bill that was presented to her by the legislature and signed off on by the speaker and the president. Director Betlak is simply implementing the statute that the legislature sent to them. They didn't cause any harm to anybody, and that's, I think, the key to standing. Frankly, Your Honors, I'm happy to answer additional questions. We've briefed fully the issues on constituent standing. I don't believe there's...
Let me make sure I understand. I think I do what you said in the last few minutes regarding what you think is properly before us and what isn't. I think you would acknowledge that if we were going to exercise jurisdiction, or if this was simply on appeal, that the standing issue and the subsection D of the constitutional provision issue are before us, but you would express reluctance as to whether the court should proceed further into C2 or any other merits.
Absolutely, Your Honor. And one other point is the petitioners concede now that the delegation separation of powers claims they don't have standing to. So there are the 2 different claims. So I don't think there's clearly any standing there. They urge that Mr. Jenny has standing, and I think it's pretty clear under the Attorney General statute that he doesn't, because this is a collection, not a payment, and it's not claimed to be illegal. So
course, even to collect it, you have to pay salaries and administrative expenses, so why isn't that always the case?
Well, there's no authority, Your Honor, for the notion that if there's some incidental cost, and by the way, there's not even any allegation that there are, and certainly no facts supporting that there are, but none of the cases can be read that broadly, and certainly not the Block case and the others. I mean, that involved a payment. And another important point is it has to be alleged to be illegal. Counsel stood up here a moment ago and said if they could find a different funding source, this assessment's perfectly fine. Well, that's by definition not illegal.
I don't think that's what counsel said.
Well,
I think counsel said if they could find a different funding source, it might make the remaining parts of the Medicare law work.
well, let me quote, because I don't mean to misquote her. I understood her, but this is a direct quote from page 40 at the argument below, where Ms. Sandifer said nothing prevents the legislature from going back and finding a constitutional funding source. So nobody's saying, and the Bennett court recognized on a taxpayer standing argument, you have to show not just an expenditure, but an illegal expenditure. And nobody's saying this is illegal. They're just saying they don't like that it didn't pass 2/3 majority. So,
Counsel, if petitioners moved for an accelerated appeal in their appeal, would you object to that?
my recollection, Your Honor, is that there are some it's limited what can be done on an accelerated appeal. And I think, again, we want it to be heard fully, properly. I can't say right here whether we would object or we wouldn't, but that's really the thing, is make sure we get it right. So I say I'm out of time. We'd urge the court to deny jurisdiction or alternatively to affirm the trial court.
Thank you, Mr. Northup. Ms. Sandifer?
Thank you. First, defendants below say that Prop 108 was passed to protect the taxpayer, and they're absolutely right on that. And the taxpayer's first line of defense is the legislature and the legislative process. If we cannot rely on the integrity of the legislative process, and exactly what defense and protection do they have? Now, defendants below go back and forth as to whether or not hospitals can sue, whether that makes a difference here or not. We do not think that it makes a difference. Now, we don't share defendants' optimism that a hospital will come forth and sue. We've got a 1-year statute of limitations on constitutional claims. A large hospital coalition filed an amicus brief in the trial court saying that they like the law, they don't want to sue because they financially benefit from it right now. And as we know, that there's an immense delegation of power to the access director to give exemptions whenever he'd like. It doesn't.
Refreshing candor, don't you think?
What's that?
Refreshing candor on the part of the hospital.
We certainly welcomed it, but Your Honor, we're in a situation where I think the way the law was designed, we could easily foresee hospitals not being able to sue simply because the statute of limitations runs. Nevertheless, regardless of whether or not a hospital can sue, has no bearing on whether petitioners here have standing. They're totally different injuries. Hospital might be injured by having an unconstitutional tax levied on it, but of course the legislators are the most directly injured because their votes are nullified here. And the private attorney general plaintiff here, Mr. Jenny, needs to assert no injury whatsoever. He's got statutory standing under the private attorney general doctrine. Now, defendants below say that, the complaint doesn't allege any sort of expenditure. Here, illegal collection is an illegal expenditure for two reasons. One is that we're using illegal money to collect and administer the taxes, as Judge Gimmel said, and Block stands exactly for that proposition. And in fact, defendants say, well, this is some sort of incidental expenditure, but that is the exact argument and protest that the dissent raised in Block. They said, look, this is an incidental expenditure, and
the dissents aren't usually very powerful.
Dissents typically not, Your Honor, and the court, of course, rejected that in Block. In fact, the court said that you can use challenge illegal expenditures of money, for exercising an illegal power. And in fact, Block went further and said, look, you don't even need to allege illegal expenditures for that purpose, because if you're saying that a power is illegal, then by definition, you're spent, as long as money's going to be spent for that, you're spending, it's an illegal expenditure because the power itself is illegal. Now, I don't believe that defendants can argue that it's not going to cost any money to collect a tax, a massive tax for a massive expansion of a brand new program. Clearly, that's going to cost money. Clearly, we're paying at least Mr. Betlak's salary here. And so there should be no problem there under the
Sounds
private.
like a fact question to me.
Your Honor, I don't believe that it is a fact question. I think that I think the court can take notice that it would cost money to administer a tax. But nevertheless, if the court found that it was a fact question, then that could certainly come out in discovery.
Let me change the subject slightly.
Sure.
I believe in your papers you have asked us to not only disagree with and vacate what the trial court ruled, but to order supplemental briefing or additional briefing from both sides so that all the merits can be addressed now.
Sure.
You heard Mr. Northup suggest that that's not really properly before us, nor would it be on an appeal if we decline special action jurisdiction. What's your response to that? Why do you think that is properly before us?
Thank you, Your Honor. In fact, we don't believe it is currently properly before you. That we asked for the additional briefing in the alternative to a remand.
But
so,
isn't there a principle that we do better when the trial court starts with something?
That's true, Your Honor, in the case that there actually needs to be a record developed. Now, I didn't hear defendants explain exactly what part of the record needed to be developed. We believe that this is a pretty clear statutory, as Judge Swan said, a statutory question here, not only on the Prop 108 issue, but also, frankly, on the delegation issue. It doesn't matter what Mr. Betlak actually does in practice. How we determine whether or not there's an illegal delegation, we determine from what the legislature itself on the face of the statute has delegated to that particular administrator. So we don't believe there are any factual issues to resolve and that this is proper for additional briefing, especially since, again, the tax is already now in effect. The program is in effect. As defendants have made very clear in their briefings both below and in this court, this program is going to affect thousands and thousands of Arizonans. If eventually this program the tax is declared unconstitutional, the legislature will have to go back and find a constitutional funding source, or otherwise we're going to have to scale back this program and kick people off the program. So with that, Your Honor, I see that I'm out of time. If there are no further questions, and we ask the court to accept special action jurisdiction and reverse the trial court.
Thank you very
Thank
much.
you.
We will take the matter under advisement and issue a ruling in due course and stand in recess now. Thank you for your arguments.
We have outreach.